Okay. Uh, uh, Good evening, everyone. Hi, my name is Ben Mirza, and I am. Today, we're going to be talking about assessing liability and how to protect professional practice and reputation. Let me get the slideshow started here. And so today we're talking about assessing liability and how to protect your professional practice and your reputation. And first of all, I want to thank South Florida Hospital News and Charles Felix for putting this together. It's just a great platform intended to actually educate physicians and really bring to them the real world things that occur that they never got educated on in school or even in residency. So today, as you'll notice, for physicians, the topics that we're going to touch on are very real world topics. So thank you, Charles, for putting it together.
And this is also brought to you by the Broward County Medical Association. Cynthia Peterson, we all got together and decided this was a good forum for physicians whenever they can make it. And if not, it resides on my website, on YouTube, and on Ben's website. So you can always review it for information that for yourself, or if somebody else would like somebody information, it's all available. And we have videos now for I think the last 2 years, various different topics.
Well, we do, and it's got pretty nice traction. All right, so just starting off with who am I? What am I doing here? Why am I the one speaking? Well, it's really because I've been an attorney for over 20 years, since about 2001. I was formerly a certified public accountant. I also have a master's of tax in corporate mergers and acquisitions, and I have a master's of public health administration from Yale, which focused on primarily strategy and policy. So with that sort of a background, I've been inside large organizations and small, including Broward Health, with other law firms, including places like American Medical Depot and certain GPOs, and just been involved in like a fair amount of corporate healthcare corporations. So today we're going to talk about how to protect your professional practice and your reputation. And the reason why I think it's so important is because very few people understand how the licensure complaints and the medical malpractice lawsuits really work as to their reputation. And for example, I was just looking up the database at the state of Florida, and the complaint against the most recent complaint that was settled was as to this physician who had been sued for medical malpractice. They settled a lawsuit. There was a payout of it, something like $250,000. And when they paid out that $250,000, the physician failed to actually report it to the state. So it wasn't the fact that they had actually had a medical malpractice issue arise, but it was the fact that they failed to report it to the state. So the way that physician decided to actually bring that complaint from the state against them to an end, it was by relinquishing their license. Now, can you imagine? You get sued for a lawsuit, you actually settle it out, but you end up relinquishing your license in the end. That's more than just $250,000 worth of damage to the physician. That's a lot more. It's a career just going right down the tubes. And for that, my heart goes out to the physician that had to go through that whole process. It must be very difficult. And the second example, let me give you, is a physician whose license was taken away for, number one, failing to follow the standard of care and failing to document a physician's file. So what happened in there was a physician that owned a wellness center, and in the wellness center they had nurse practitioners working. So he was supervising these nurse practitioners, and as they were supervising them, in comes this one patient. It's a new patient. The patient's got pain med issues, and they have their blood markers. Sorry to butcher it up, but their chemical levels in their body were way off. And what ended up happening is that the physician's nurse practitioner ended up administering all kinds of vitamin supplements and just a ton of different alternative techniques, as well as pain meds to this patient, and they failed to document what was actually occurring. Number one, they didn't document that they did a physical. Number two, when they did take a blood sample and they got the test back, they did not actually react to those, didn't call up the patient, didn't have them come in, didn't do any of that sort of stuff. And then when the patient got worse, they went from okay to worse, they ended up in the hospital. They called up the same physician and said, hey, I'm in the hospital, what should I do? Well, according to the record, it appears that the physician tried to talk the patient out of the hospital and returned back to his practice. So, there were a lot of problems with that. So today we're going to talk about things like that and how that can affect a physician's license. So before we get started, here is a economic study done by the American Economic Association.
Ben, let me stop you for a second. Can you go back
Sure.
and put that what do you call it?
Sure.
Disclosure or the
Oh yeah, disclosure. Oh, by the way, today's seminar is not intended to be legal advice, and it's only intended for informational purposes. It's only an educational session. So if you have a specific question, you may want to call me or email me, and we can discuss it directly. But otherwise, today's session is only a informational session. Also, do know that there's no products or services that are being talked about today that are to be consumed by patients. So there's no disclosure, there's no inherent conflict of interest here with regard to physicians and their practices. So going on to the economic study, in this economic study, what it actually proved to me as I read it was that a physician's efficacy drives their reputation, and their reputation drives market share. So here's an economic study done by the American Economic Association, and what they basically said is that a classic signpost of competition in manufacturing industry is that higher performing hospitals have a higher market share and grow more over time. And what they also said in that study is that patients are willing to travel 1.8 miles more to a hospital that has a 1% higher survival rate. So in this case, they were specifically looking at acute myocardial infarctions and the survival rate related to that. So if a hospital had a 1% higher survival rate as to those sorts of patients who were willing to travel 1.8 miles more. That's only simply based on 1 percentage point. So does your reputation matter? Of course it matters. Does the efficacy of what you do matter? Yes, it does. And this study would indicate that it also drives market share and longevity of your business. So when it comes to actually market forces, what we're looking at is there's a physician and there's a team. The physician is the head of that team. That team drives not only business, but it also drives quality scores and it drives Google reviews, which all go into the following of that physician. Now, built into all of this, the way you get better reviews and better quality is by actually embracing human values or customer values and being more of more about respect and accountability. Do remember that should professionalism be disposed of or done away with, it also means that your license is potentially under attack. And if your license is under attack, and if it's ever taken, no license, no money. So as you know, a lot of lawyers also believe this, which is you can take away pretty much almost anything from any one of us highly licensed professionals. But if you take away the license, you're taking away the ability to earn a livelihood. And it's got drastic ramifications to that. So with that said, today we're going to be talking about, it's going to be a 4-part roadmap. First, we're going to talk about the regulatory body in Florida and how that's set up. Then we're going to talk about the disciplinary process, and then we're going to talk about the medical malpractice lawsuits. And last but not least, we're going to talk a little bit about Google reviews and developing a following, and how that can be so key to what your next stepping stone is going to be in your life and career. And so I urge you to actually, especially hang in there for the last part. So first, starting off, physicians are professionals. They're expected to be altruistic. They are expected to have no financial interest in anything that they do. I mean, it's just, they can't get referrals. They can't do fee splitting. They can't sell really products that they can't benefit off of other people selling products, right? There are in-office sales of products, but when they're outside of the office, they can't be, like, for example, referring patients to a particular pharmaceutical drug and be getting a benefit on the backside of it. There are certain exceptions to that, and if you need those exceptions, call me and I'll walk you through them. But that's the general rule. The other thing is, when it comes to actually personal interest, the Florida Board of Medicine takes sexual activity or influence over a patient as a big no-no. It's actually a red flag that is dealt with swiftly and harshly. So if anything like that occurs in a physician's life, where there's patient-physician improprieties, they've got to really take cover and make sure that they straighten up their act. The other thing is alcohol and drugs, which can impair reasonable skills of a physician, are also viewed by the board. So, and then there's, last but not least, failing to report others who are in violation is also, believe it or not, a violation. So, for example, if you're a physician and you're practicing with another physician that's doing illegal, improper things, and you fail to report them, it's deemed to be a violation committed by you for failing to report them. Now, that's a double-edged sword, and that's a harder one, but nonetheless, it is out there. So let's start off with the regulatory body and what the regulatory body in Florida looks like. Here's a organization chart of how the regulatory body in Florida is set up. If you notice at the top, way at the top up here is really the governor, and to the governor report a bunch of different departments, and one of them actually happens to be run by the state surgeon general, which is the Department of Health. And within the Department of Health, there's a deputy secretary of operations, and under that deputy secretary of operations, there is a medical quality assurance group, and it goes on down. And then there's the executive board. There's actually 22 different executive boards just under this group alone. And then there's actually other executive boards as well, but under this group, it's 22 boards. So the ones that we're going to concern ourselves with today are really going to be the Bureau of Enforcement, the Bureau of Operations, and the Bureau of Healthcare Practitioner Regulations. The Bureau of Healthcare Practitioner Regulations, which is all the way at the bottom, it really regulates 7 types of facilities, 200 different types of licenses, and about 40 healthcare professions. And there are 22 boards in there. So today, our primary concern is going to be about Board of Osteopathic Medicine, which is referred to as BOOM, and then Board of Podiatric Medicine, and the Board of Medicine itself. So each one has different number of members, different number of consumers, and different number of physicians. As you can see on this slide, if you need to know this, you may want to pull out your cameras and take pictures. If you do need any of these slides, you're welcome to take pictures of them. And it's always handy to have them on your camera. So if you need this, please do take a picture. Do remember that the terms of these board members is generally for 4 years, and all of these positions are appointed by the governor. The executive board has responsibilities over licensure, monitoring, disciplinary proceedings, education, and a few other things, right? So today our focus is going to be on the actual disciplinary proceedings. Now, let's talk about disciplinary proceedings. Here it is. This next part is about medical complaints and the disciplinary process. But before we start on the actual disciplinary process, let's kind of get an understanding of what disciplinary complaints entail. Number one, there's actually complaints about customer service. If there's a complaint, if you go to the Florida Health Care complaint portal, like I show on this picture, if you go to that Florida Healthcare complaint portal, there is a customer. If you have a customer service complaint, what they're going to do is they're going to redirect you to go back and speak to the practice manager. If you have a HIPAA violation, meaning the protected health information of a patient somehow is misused, they're going to report you to. Then they're going to suggest that the person who's complaining go to HHS. Next is actually general billing issues. If there is general billing issues that are problematic, they're going to tell the patient to go to the Florida Department of Agriculture and Consumer Services, and from there the Consumer Services Division will take over the complaint and review it. If there is a balanced billing issue, that is referred to the Department of Health, and if there are insurance coverage issues, they're going to refer you to Medicaid or Florida CFO, Division of Consumer Services, because that's where a lot of the insurance issues are handled. Then all the other issues, as some of the ones that we had talked about earlier, are then handled by the Department of Health. So it's all the other issues that would fall under the Board of Medicine, frankly. So that's what we're going to focus on today. So who files a complaint? Number one, it's typically a patient or a disgruntled employee or another physician. And even competitors, believe it or not, will file a complaint against another individual, another laboratory, another lab, another referral source for somebody. They will actually go and report them. If you notice on the bottom, there's a section here that says self-reporting. Yeah, physicians are actually required to do some level of self-reporting if there's something improper that occurs. Like, for example, if there's a DUI that the physician gets, and not just the DUI, but they're convicted of a DUI, they need to actually report that to the Board of Medicine. If there is a lawsuit settlement, that's also considered to be self-reporting, and you've got to go and report it. So, but the most common complaints in the department are about not updating a physician's profile, that medical records were not reproduced, that there were maybe somehow adverse incidents due to a particular prescription or some sort of a procedure, and last but not least, sexual misconduct of a physician. And here's a form on this left-hand side, as you can see. That's about that's what the complaint form looks like. So the Florida statute that actually applies to this is 456.073. So if you're really interested, keenly interested on following up and figuring out how this process works, what I suggest you do is take a look at Florida statute 456.073. So what are they looking for in a complaint against a physician? So the department, what they'll do is they'll take that piece of paper, or in this case, it's an online portal. They'll take that and they'll first of all want to make sure that, number one, it has to be in writing, right? So if it's not in writing, they won't take it. A verbal complaint is not something that they will take. It has to be signed by the person who's filing it. And it must allege ultimate facts of some sort of a violation of law or practice act or some sort of a rule. If it doesn't allege that, they're going to toss it out. Now, if it passes that level of muster, mustard, get it? So if it passes that level of muster, what they're going to do is they're going to have an investigator look into it. And the investigator may actually request for documentation from the physician, from the patient that's complaining, or anybody else who's actually complaining. But that's how that's how the complaint comes in. When the complaint comes in, it comes in over here in this red box with the arrow on top. When it comes in, the department takes it, they review it, they analyze it, and then they figure out, well, is this something worth looking into, or do they just go and say, this is not something worth looking into, and they just dismiss it, or they'll issue some. If it's a minor violation, they'll just issue a citation. Like, for example, not having your your address up to date, right? So that's a minor violation. It's a citation. It just has to be fixed. It's quick. It's easy. You just got to fix it, right? But if it's something serious, then it's referred over to an investigator, and then the investigator gets involved, and they will look thoroughly through all of the underlying records and decide whether it's something that's worth giving to the prosecutor. Then the prosecuting attorney will review it and take it before a probable cause panel, like over here. So the complaint comes in, it gets reviewed, it gets handed over to an investigator. The investigator looks at it, and then what they'll do is they'll take it over to prosecution. The prosecuting attorney reviews it, and it goes over to the probable cause panel. Then the probable cause panel either says, we need more information, we can't decide based on what we have, or they say, hey, let's either dismiss this case, or let's proceed to filing a administrative complaint. So if you notice this red line here that's on this slide, if it's before this, in this part of the screen, everything is confidential, nothing is in the public's eye. Everything is discussed between the department and the physician and the party that's complaining. However, once the administrative complaint down here is filed, it all becomes public and it's out in the open. And then the physician is given their election of rights. They have the right to get an attorney. They can actually even get an attorney in this investigation process if they need to, and sometimes they do. And sometimes I've been retained just to come in during the investigation process. And then it follows its normal channel of prosecution. And there's a whole discovery. There's an answer, there's discovery, then there's an actual adjudication or a hearing had, and at the end there's a final order. If somebody happens to disagree with that final order, meaning namely the physician, they can appeal it. But the way that you have to appeal it is that you have to go to the District Court of Appeals of where that hearing was held in order to appeal it. Again, this is a fairly costly process. That's why I want you to kind of understand what the lay of the land looks like, because just in case, if you or one of your friends happens to be involved in something like this, I think you need to get an understanding of what this is about. So what does the Department of Health do with a complaint? Number one, they'll either dismiss it, issue a citation, or refer to mediation, or refer to investigation. Those are your four basic options. Now, what happens when the investigation begins? If they give it to an investigator, the investigator usually serves in the Investigative Services Unit, the ISU, right? And then the Department of Health will notify the physician or the professional under investigation that they're being investigated. The professional then has the right, while it's under investigation, I'm kind of going back and repeating myself. Remember, back to this first part, we're in here. I'm just recapping it for you. So then the physician can go and get an attorney and respond to the investigation. Now, do keep in mind that the physician has a right to get a complete copy of their investigative file. So whatever's in it, the state has to produce it, so you know exactly what the evidence is against you. So let's say that the prosecutors decide to actually press forward. What they'll do is they'll take the case before a probable cause panel, and the probable cause panel will take and review the complaint, and they will come up with those recommendations, either to send it back for more facts, so they'll send it back to the investigator. They might even dismiss it. That's a possibility as well, although that's rare. Or they'll close it out with a letter of guidance, sending a letter to the physician, basically saying, hey, don't do this again, or some sort of a reprimand, but they won't proceed forward. Now, however, if they do find probable cause and sufficient cause to proceed forward, then that's when they will file the administrative complaint. And the administrative complaint kind of looks like this. It's got the state of Florida up top. It'll be from the Department of Health, and it'll be against a certain individual who is the respondent and typically the physician. And it's titled administrative complaint. And it'll have a case number on it. So what'll happen is that the administrative complaint is served either by certified mail or personal service. And usually If it's going to get to this level, there will be a personal service person usually showing up. But remember, they're not required to actually have somebody knock on your door and deliver that complaint. Oh, they can serve it by certified mail. And if the physician is nowhere to be found in the state of Florida, they'll do it through publication, and that's considered constructive service, meaning that they'll put the notification in a newspaper, and once they've published it in a newspaper, it's deemed to have been served, and the board will proceed forward. Now, remember, the subject, the person who is going to be the respondent to that complaint, must select the type of hearing within 21 days. So they can ask for an informal hearing or a formal hearing. So those are two different things, right? So if they ask for an informal hearing, what they are disputing is the law, not the facts. But if they're disputing the facts, they have to ask for a formal hearing, which means that there's going to be a full administrative law judge assigned to the case. However, keep in mind, majority of the cases are settled. They usually do not go fully through the court system to be adjudicated upon. They're usually settled or defaulted. And in this course and process, there is actually a burden of proof. Do know that if the state is looking to take away a professional's license, meaning that they're looking to revoke it, that the burden of proof has to rise to the level of clear and convincing evidence. However, if they're not seeking a revocation, they're seeking something less, it just has to be the greater weight of the evidence. So like 51% would do it, right? Anything over 50% would be considered greater weight of the evidence. But if they're seeking to take away the license, it's got to be clear and convincing, meaning that there's no doubt in their mind that that's exactly how things happen. So these cases are handled much like a regular bench trial, and that's really about what you need to know so far as to how the process works. At the end, what will happen is the person is either suspended, or their license is suspended or permanently revoked. They could be restricted as to the area of practice that they're in. Their license could also be restricted, or they could even be fined, or a combination thereof. Corrective actions can also be administered on the individual. They could even have like some sort of a monitoring or remedial plan put into place. I saw one case in which the physician was required to have 50% of their files reviewed by another physician, basically saying that it met the standard of care. 50% of their files had to be reviewed by another physician, and the cost of that monitoring has to be paid for by the physician. It's not like the state is going to pay for it. The physician has to pay for it. So, but do remember that, do note this actually, that if a case is dismissed and that it was unreasonable for the government to have taken that action, there is a statute out there called 57.111, which allows for attorney's fees when there's unreasonable government action against an individual. So that does exist out there, but again, that's rarely ever used. It rarely ever does it get to that point, but it does happen. Okay, now we're going to talk about what happens if something adverse happens, right? So if there's an adverse decision that's found by the Department of Health, then remember it has to be reported to the National Provider Data Bank, which is NPDB. You could lose payor contracts, meaning like the health plan contracts. It could mean a loss of hospital privileges, and it could also mean that if you're licensed in multiple states, that other states might decide to follow the state of Florida and say, hey, we're going to take the same action against you, because if you committed that against a patient, it affects your license not just in Florida but everywhere else too. So yeah, could be a bunch of things. And if you're dealing with like controlled substances and improper prescriptions, yeah, the DEA, the Drug Enforcement Agency, can take action against you. Do note that I think one of the biggest harms that also comes out of this is that the information is on the internet, and everybody can actually see what happened in that case. But if you're found to be not guilty, remember, there is that attorney's fees. And if you're appealing, remember, you have to appeal to the District Court of Appeals in the area where the case took place. Now, the most common disciplinary actions is um, medical records were not produced, that there were illegal prescriptions being prescribed, that the practitioner profile was not updated, that the advertising rules were not being followed, or that there were adverse incidents that took place. Wrong site person or surgery. I mean, wrong site surgery is a big issue that I'm sure you guys have heard about. These kinds of things are common situations that invoke a disciplinary action. Now let's talk about medical malpractice lawsuits. I know I'm rolling pretty fast on you guys, but just stick with me. So first, let's talk a little bit about the do's and don'ts of what a physician should do and can do or should not do. So in this cartoon, you see over here, the physician is talking to the patient. The patient is saying on their T-shirt, it says, "I hate doctors," and the physician is saying, "I'm happy to see you too." So again, with a little bit of humor, I think you've got to take the higher road whenever you are with a patient. But when you talk to them, do talk to them at eye level, one-to-one. Reason with them like if they're a member of your family, and just treat them as if they were a part of you, right? So that's why you got into medicine. Also keep in mind infection control, no touching of your ties. Do not wear a tie if you can avoid it, especially in clinical settings. Pens, phones, iPads, tablets, they all have a potential for infection control, so do take measures against that. Also keep in mind to have a team approach with your team, that if you say something improper to your teammate in front of a patient, it doesn't look right. If you've got to actually discipline a teammate about something, or reprimand them, or say something to them, or let's say it's somebody that's above you and you need to say something to them, do it behind the curtain. Don't do it in front of where the patient sits. So that's a part of just making sure you hold your demeanor, your elegance, your respect for everybody in the room. You remember that there is a patient-physician confidentiality relationship. That if you're treating family members, you got to be very careful that you do not tell the other family members as to what's bothering one of their family members. So just remember to be approachable. That's a big part of why physicians, I believe, pick up complaints, because they are not approachable and they're talking down to patients. So these are some of the do's and don'ts. Take timely notes. It increases your accuracy. And also keep in mind that you do have the right to fire a patient. Firing a patient is not that hard. It's pretty easy to do. All you have to do is send them a letter. The letter, we have it on our website. If you actually just if you're looking in for that letter, it's on our website. Here's the actual domain or the address for it. It's at mirzahealthlaw.com/sample patient termination letter or discharge letter, and you'll see it. If you just Google it, you'll find it. Otherwise, just email me and I can send it to you as well. It's all ready to go. All you have to do is put in the names and the addresses, and you can let it fly. So the reason why I want to touch on firing a patient, why that's so important, is because patients that are problematic are not only problematic in terms of medical care, but they could have repercussions, meaning a complaint against your license, a complaint against you in court, meaning a lawsuit. So like if a patient is non-compliant, if they don't come in on their appointments, if they don't follow your orders, if they are just think that you are not doing enough for them, then you may want to consider getting rid of that patient. I do urge my clients to actually take this to heart and get rid of their problematic patients, because some of these patients are literally just looking for trouble, and you got to know which ones are which. And sometimes it's real concerns, and you're going to have to weigh that out, because sometimes the patients have actual and real concerns, and you've got to take those into account and make sure that you're dealing with the patient's problems, because after all, that's why you became a physician. So you're going to have to do a balancing act, but nonetheless, there is a way to terminate them. Now, let's say, how do you know that you are about to about to get sued? Well, there's no real way to know, except what I can tell you is if a patient threatens you, you know that's problematic. If a patient says, hey, I'm going to sue you, that's pretty blunt, that's pretty obvious. Even if you don't think that they meant it, I would take those words very seriously, and I'd consider having them move on to another physician. The other thing is, a lawyer may request to meet with the physician ahead of the lawsuit. There may be a request for medical records or information from the patient. And if you know that there's been trouble in the past, that if a patient is asking for certain medical records, you know, that might be problematic. So make sure that your files are nicely documented, that they're properly documented, that if you gave somebody orders on what to do and they're not following it, make sure it's in the file that they said that they did not follow your orders. And then remember, a complaint against the physician's license can sometimes lead to lawsuits as well. So a lot of times what will happen is the patient will go and complain to the state of Florida. Once that complaint pushes forward and the physician is found to have done some sort of a wrongdoing, it can lead to a lawsuit. So that's just, you know, I mean, that's just kind of common sense, but I don't think enough physicians realize it. Also, there is what's called a letter of intent to sue. There is a letter that attorneys have to send over to the physician before they actually sue them for malpractice, and that's required by statute. So if you get one of those, you know that there's probably a pretty good chance that a medical malpractice claim is coming your way, and that's how you know. Those are the hints, right?
Hey, Ben,
Now, yes.
would you mind on that last slide pointing out with the different colors? I can't read that on the screen. America's medical liability crisis, yeah.
Yeah, so in that case, this is actually an older clip from the AMA website. This is, I think, a fairly old clip, so it's probably like 5 or 7 years old. However, what they were saying is that the hot spots are in red, meaning in terms of lawsuits or medical malpractice lawsuits being filed. The yellows are somewhat on the rise, and the white states are the ones that, you know, that the medical malpractice lawsuits have stayed even. So this is a bit of a dated map. Last I looked a few months ago, AMA had not updated this map since then. So I imagine we're probably in the same sort of a status. Florida is probably still one of the more hotter states of where medical malpractice lawsuits continue to be on the rise. So yeah, I think it's really important to actually pick up medical malpractice insurance in Florida. I know that there's people who like to go bare, but going bare has its consequences, and it has its own set of I think it's almost like a 10-part criteria that you have to meet if you're going to go bare. Going bare means going without medical malpractice insurance. And in the state of Florida, I would definitely recommend any physician or a practice group to make sure that they carry medical malpractice. Believe it or not, some people don't, even some of my clients don't. So just know that is an option, but it's kind of a double-edged sword too, because if you talk to some of these insurance folks, they'll also tell you that if you don't carry insurance, you're less likely to get sued. Although that may be statistically accurate, I wouldn't necessarily want to take chances with my license on something that's statistically on one side or the other. I would actually opt for carrying insurance. That's just a personal bias I have. So let's talk about the types of lawsuits that can come at a physician. It could be for failure to respond to emergency calls. It could be for failure to respond to requests. It could be for misdiagnosing a patient, like the earlier example that I gave you. There was a patient that came in. They had certain blood levels that were kind of out of whack. The physician didn't even look at it. I mean, is that misdiagnosis or failure to diagnose altogether, period, right? So you can't even say delay in diagnosis in that scenario, because they just didn't even diagnose it, right? So meaning if you should have caught it earlier on and you didn't, but you found it like 3 months too late before it turned into a bigger issue or a bigger medical condition, that would be a delay in diagnosis. But not even diagnosing something that's bluntly right in front of you is really problematic. There could be a failure to order or to read diagnostics tests like the one that we just talked about. A failure to refer. Physicians should also know when something is outside of their purview, outside of their expertise. You've got to take heed to that. I'm always a big proponent of second opinions when it comes to healthcare. If there's anything major going on with a person, do send them to a specialist, and not just one. I think sometimes two more. If it's a serious enough issue, they should probably see more than one specialist. And lack of documentation, like I had mentioned earlier on, that last complaint where the physician lost their license altogether. It was also due to not only the failure to read diagnostic tests, but it was also a failure to document a physical examination of a patient. It's problematic. So just make sure you're documenting properly if you're a physician. So in the state of Florida, how do lawsuits happen? If a lawsuit does get filed, what'll happen is that a process server will knock on the physician's door. They will knock and deliver an actual lawsuit, which will probably be about yay thick. And from there on out, the physician will have 20 days from the date of service to respond to the complaint. That's 20 calendar days, not business days. A lot of people think it's, for some reason, because it's a legal proceeding, that they have business days. That is not true. It's only calendar days. And those 20 days can be tricky. Whenever I calculate the 20 days, I do it sitting down with a calendar open in front of me. So do know that it can be tricky because 28 days versus 30 days versus 31 days can be problematic. And you have to have the specific date of when it was actually served to be able to calculate that. It's simple, but people like me who are somewhat very specific about things, they will use a calendar. And then the complaint literally has to be a short and plain statement of facts, but it's usually not. It's usually a fairly prolonged document. Most of them range from 10 to 15 pages, and plus they'll have attachments to the back of it. Do remember that anything that's in court has to be redacted as it relates to PHI. So like date of birth, the individual's name, et cetera, et cetera. So that sort of stuff has to be redacted. Now on the complaint, obviously the patient name will already be there. But other than that, everything else is considered PHI. So that all has to be redacted. Now, the typical defendants in a lawsuit are the physician, the hospital, the nurses, and the labs. So those are your typical defendants. And then the state, then what will happen is that the lawsuit ensues, and there will also be a phase of discovery. Discovery means that you have the right to ask for documents. The other side has a right to ask for documents, and they can ask questions through interrogatories. They can ask you written questions, and they can ask you oral questions. When they ask oral questions, they can actually haul in the witness and depose them, and vice versa. The physician can do the same. They can actually haul in, let's say, the patient or even their family member, and depose them as well. The venue, meaning where the case will take place, will typically be the county where the wrongful act occurred. So like, for example, if the physician's practice is in Broward County, typically the lawsuit will be filed in Broward County, because that's where the physician and probably the patient also live in the same county. Sometimes they do cross borders, and that'll really depend on the attorney and what they decide. So how do you go about proving a case? Right. So there is a 4-part element that any plaintiff has to prove when they file a lawsuit. Number one, they have to show that the physician had a duty. Number two, that the physician fell below the standard of care and they breached that duty, and that there is cause. Hi, Benjamin. I'm going to continue on. Sorry about that, Charles. And then you have to show causation and failure or injury or harm to the patient. This is a protracted sort of a process where you have to go through all of this discovery and getting expert witnesses to actually testify on both parties' behalf to make sure that the blame is being pinned the right way. I've been involved in cases where the nurses to a particular hospital did the wrongdoing, but the physician was the one who got blamed. Now remember, in a hospital setting where a physician has privileges to a hospital, when they perform a procedure in there, the nurses that are going to be in the OR are employed by the hospital. So if the nurses do something wrong, who is to blame? Meaning the physician who was overseeing the whole procedure or the hospital? Chances are they'll blame both, the hospital as well as the physician, and probably even the nurses themselves. So that's law 101 in terms of a lawsuit for negligence. So how long does a lawsuit take? This is a timeline that I've used many a times to explain to my clients how long a lawsuit takes. If you notice the first part up here in kind of a beige, that's where the notices are going back and forth of the breach. There may be a request for records that's also going on simultaneous to those notices, but then eventually, like over here, after a few months, there's a lawsuit filed, which would be like, let's say, around the 3rd, 4th, or 5th month of receiving the first notice. And then it takes on its very own long course before it gets finally either settled or adjudicated. If somebody gets sued, just know that it's actually a 2-year process. Okay, so because of this, I encourage people to actually carry medical malpractice insurance, because the insurance will pay for the legal fees of defending the physician. To go for the long haul of 2 years of defending a medical malpractice case is really a long time, and it's very, very costly. So God forbid, should somebody need help as to that, and they happen to go bare, I mean, God help them. It's just a really expensive road to go through. So do's and don'ts after you receive legal paperwork. If you receive a intent to sue letter or a complaint, immediately notify your corporate risk management or your insurance company if you happen to not be inside a big corporation. The next thing that you want to look at is you want to make sure that if you're self-insured, you got to hire an attorney. And if you're meaning that if you're going bare, so to speak, you're going to have to go and hire an attorney, and you cannot use any of the monies that are sitting in your bond or your letter of credit towards hiring of that attorney and paying for those legal fees. But you are entitled to obviously getting an attorney. Now, if you go through an insurance company, you will be entitled to legal counsel that the insurance company hires. But this is where the catch is. I don't think that the insurance company attorneys always have the best interest of the physician at heart. They help, and they help significantly, but they don't understand the intricacies of what the reporting requirements are for a physician. So what will happen is they will proceed forward with settling a claim, let's say, but when they do the settlement, the physician's name is in the settlement. And guess what? We started this lecture about, if you ever settle a claim and your name is in that settlement, you've got to report. You got to self-report to the state of Florida that you settled a case. So that's problematic. That's why you get guys like me involved that don't have a dog in the fight in terms of the insurance company, and obviously don't represent the plaintiff. All people like me do is we represent the physicians that are involved in that fight. So that's what they do. In this case, what I'm showing you here is that 90% of the work will be done by the insurance legal counsel. So you typically wouldn't have to pay for that. Whereas a guy like me who's involved would be your personal counsel. And we do about 10% of the work as compared to the actual insurance counsel. So the relative expense of paying for somebody like that is pretty minimal. And it's like a nice way to make sure that you end up in the best situation possible. So what do you get out of this? Make sure you get yourself a personal counsel, and they'll help you get extracted out of that lawsuit. We're coming up to the 50-minute mark, so this is our last slide. And I really want to talk about this slide in a different sort of way. I want to talk about it because Google reviews actually hold up your credibility or lack of credibility. Google reviews add to your credibility because, number one, they will build name trust. So I encourage you to engage in the internet process, because that's what's happening. Medicine is getting Amazoned. Get that? Amazoned. So medicine is getting Amazon. So everybody's starting to get star ratings, okay? Whether it's lawyers and whether it's doctors. So what happens when you get these star ratings or Google star ratings is that you rank higher in the SEO levels, which is the search engines will rank you higher. And the higher you rank, the better patient following you'll have. Now, God forbid, if you happen to leave work and you decide to go somewhere else, how would your patients find you? You got to have an internet presence in order for people to find you, because most of the non-competes, if not all of them, prohibit a physician from soliciting their former patients in a particular practice. So how would those patients in the old practice that a person was at know where to find you? Well, number one, I encourage you to actually develop a personal page, connect to your patients on LinkedIn, even on Facebook, although I think Facebook is more personal, but I encourage you to actually connect with your patient through a personal web page and maybe LinkedIn. And then when you do that, I would encourage you to even sign up for like the Google reviews. I mean, I do it down here. If you notice on this slide, here's my Google reviews. And really, I just caught on to this idea recently within the last year. And I've got like 30 something reviews, and they're all pretty decent. And all you're doing is you're asking your clients or patients to give you a review. And keep in mind, there are other monitoring websites as well, like ZocDoc, WebMD, and HealthGrades. And you got to try to keep up with those too, because you got to make sure that your information is current. You got to make sure that you're getting decent ratings on that. It's important to you. It's going to be important to your quality scores. It's going to be ultimately important to your reimbursement rates too, because as more and more of the U.S. population falls under capitated rates or under the capitation reimbursement payment plans, these quality ratings will matter. So that's why I urge you to take on the internet and start to get yourself out there. I encourage you to maybe start up a website. It could be just as simple as your name, like it could be benmirza.com, or like just create one, right? And follow through on it. So here's if you notice this camera, it's on here too. Just do take a picture of this and do follow through, because I think it's going to serve you well in the next 5 years. With that said, I'm at the end of my seminar. If anybody has any questions, I am happy to discuss them.
Ben, that was excellent. Excellent, Ben. So tell me in just one short sentence, from the doctors that are on tonight, what should they do first thing tomorrow after listening to the seminar? What should they check? What checklist should they use to make sure that they're covered, regardless of what type of medicine they're practicing? They could be practicing regular medicine. They could be a director. How would that work? So say you're not practicing medicine, but you're a director of an operation as a medical director, but you're not actually practicing medicine, and something happens there. Do you lose your license?
Yeah, that's problematic, right? Because now that particular, let's say the wellness center has picked you up as a medical director of that wellness center. And as long as you're registered or attached to that wellness center, the patients that are walking in, they don't really know if you're a massage place or if you're an actual clinic. They don't know the difference between one or the other. But if your frontline workers are are conveying a message that they are getting some sort of medical treatment and your name is in the background, even though you may not have even seen the patient, that's problematic. So the first thing I would do is, number one, I would look for insurance policies. I'd make sure that that particular clinic, wellness center, whatever you want to call it, has its own insurance. Number two, you want to make sure that you've got insurance as well. And number three, you want to make sure that you set up the relationship through arm's length contracts between you and that particular center. So those would be, just for starters, that's what I would do. Yeah. Does that make sense?
And what about those doctors that are working kind of on a part-time basis? Say at one of these what go dock in the boxes, and I won't use any name, but dock in the boxes, and they may be doing maybe 10 hours a week or 5 hours a week covering such and such. How does that work? Yeah.
The liability is still the same, because at the end of the day, if you're supposed to be spending 10 hours watching a facility that has nurse practitioners in it, you're still deemed the supervisor of that facility, even though majority of the work is being done by, let's say, nurse practitioners, and you may be on call and you're getting paid for 10 hours of on call through the whole entire week. That's problematic because it's happening under your watch. Now, let's say if you're designated to be there on a particular day, like it happens in like hospitals, and that error or omission occurs under your watch, then obviously that would be a lot more narrower. But I think you're kind of referring to the medical director situations.
Correct. Yes.
Medical director situations are problematic. I think people take them very lightly,
Right.
a lot lighter than they should. I know that there are physicians out there that are giving away the right to use their license as the medical director for less than $1,000 a month. And sure, if you have 200 of them, that can add up to be a lot. But if you have one or two facilities that are paying you, let's say $500 a month, and you're accumulating an extra grand a month, is that worth your risk? Because you're not there on site. You don't know the staff. You don't know their procedures, protocols, what they're using in that facility. There may be other licenses on the line, meaning like a nurse or a nurse practitioner, but still, it's going to all fall on the physician. It's highly problematic for me as somebody who assesses risk on behalf of his clients.
And let me ask you a non-medical type situation. So what happens if you're working at one of these clinics and it's not a clinical error or a clinical situation, but it's what we call the white crime, where you're basically, it's a billing situation, which you have nothing to do with. So let's say it's Medicare fraud, Medicaid fraud. Does it affect your license?
Yeah, it can. Absolutely, Charles. I mean, that's a really good question. And I actually take a keen look at that whenever I review employment agreements, because there's somebody else that's billing under your NPI number, right? The National Provider Identification Number. The NPI number is yours as the physician. And whatever goes out under that NPI number is your liability. It's yours to be had, and it's your liability. So to me, it's highly important how these places bill out under a physician's NPI number.
Good.
And they can get sucked into these sorts of False Claims Act issues, or well, what else? The Stark Law violations and the anti-kickback statute violations. Yeah, those are all possibilities. And I don't think that physicians pay enough attention to it, because it's just not something that that's ever really been explained to them when they were in medical school.
Joe, you have a question?
Yeah, I do. Ben, after being sued, what should a physician not do as far as maintaining HIPAA? What do you tell your staff? How do you treat your patient? That kind of thing.
Yeah, that's a really good question, Joe. I've never been asked that question. But I mean, obviously what I would do is I would actually keep it under wraps. You don't treat anybody any differently. You don't let it get outside, because I think, number one, you're innocent until proven guilty. You got to follow that sort of a motto. And if your staff knows about it, ask them to keep it confidential, because it is confidential information to a certain extent, even though there may be court papers that are already out there in the public forum, but everything that happened behind the scenes is all private. So, you know, I would keep it quiet as much as you can.
Are there any
And I
other
would
questions? Any other questions from anybody out there?
Ben, this is Mark Bivens. Are there any things that would be prohibited or should not even be considered when it might come to any kinds of incentives or offerings to patients in order to complete reviews for you on some of the online sites? You know, is there anything that's permissible?
Yeah, I mean, I've heard of people giving, you know, certain freebies, but I wouldn't go down that road, Dr. Bevins. I just think it's problematic to actually give anything to a patient for free. You know, and I don't think you need it. I think as a physician, there's a certain level of commanding of respect and decorum that you carry as a physician. If you just ask a patient, hey, can you put in a review for me? I think they will. It's just a one simple sentence, and you know, you can even set it up where, for example, I go to a particular dentist, and when I leave that dentist office, I get a text message that says, "Rank us. How did we do?" And it goes straight to their Google review page. And I tell you, my dentist, I think, has something like 700 reviews in their profile, in their Google profile. And all it was a simple text message that goes out from the system, and it's an automated system text message that goes out straight over to the patient's cell phone. It's a really nice way to ask for a review. They know the patient knows exactly where to go to, and there's $0 being paid. There's no, you know, there's no favors being given. So I would steer clear of those things, because you just don't know how it's going to come back at you. But if there's a particular situation that perhaps a marketing team wants to run, you know, they really should check with their attorney about it. Have them call me if they don't have one. But yeah, that's kind of problematic for me. I'd be against it.
Well,
It
Ben,
has to get vetted.
I appreciate it. And it's we're a little bit past the hour, but we do like to keep these things to an hour. So again, Ben, why don't you give everybody your information where they can reach you if they need to get hold of you?
Everybody needs to reach me. My email is bam@mirzahealthlaw.com, and it's, if you just go to mirzahealthlaw.com, it's easy to find. I'm also reachable by cell and text. Texting is probably the easiest way to get a hold of me, and then we can set up a time to talk. You know, typically my engagements begin with an email with key documents, and then what I do is I review them, and then I sit down with the client. Typically, I represent the small to mid-sized companies and guys, so I very rarely have a conflict of interest with others. So, but before anyone does send me an email, I do like for them to text me at least ahead of time, so I know that something's coming and I can make sure that I flush it out. So that's how somebody can engage me if they need to. But anyway, hopefully you don't. Hopefully you don't need me.
Thanks, Ben. And Ben's always available for just a quick conversation if you do have any questions regarding this topic or any other topic relating to your practice. Ben is knows the law as it relates to both hospitals and doctor practices. So with that, until next time, our next seminar will be in December, and you'll be getting an email actually coming up on Thursday. You'll get the email with the upcoming one in December. And we hope that you all have a very, very nice Thanksgiving, and hopefully with family and friends. And we'll see you in December. And thanks for joining us tonight.
Thank you.
Okay, bye-bye.
Thank you. Have a good night.
Okay. Bye.